The United States government has collected the telephone records of everybody in the world, including Americans. We didn't know this until Edward Snowden, a former National Security Agency subcontractor, revealed the program. Now we do, and that is just the start of the story. One government surveillance program that I'd like to discuss with you today collects something called metadata. That is, data about data. Who called you, when you called them, and for how long, instead of the actual content of the communication, such as what you said to your mother when you spoke to her the other evening. The program is known as the Section 215 program, after the section of U.S. law that authorizes it. Or does the law authorize the program? The legal jury, as we shall see, is still out. The Section 215 program is, I think, an ideal lens through which to look at the effects of changing technologies on the law and to ask some fundamental questions like, what is surveillance anyway? And why is metadata different from just plain data? Or is it really different? The Section 215 metadata collection program arises from the USA Patriot Act, which was signed into law in October 2001, and which gave rise to an accompanying series of orders issued by the Foreign Intelligence Surveillance Court, or FISC. The orders required telephone companies operating in the United States to provide the National Security Agency with what are known as call detail records. That is, the detailed information of the sort that typically appears on your telephone bill, including the date, time, and duration of a call, and the phone number to which the call was placed or from which it was received. As described by the Privacy and Civil Liberties Oversight Board, this Section 215 metadata was to be maintained by the NSA in a centralized database. NSA analysts can search the database with a query, that is, an input of a search term like a phone number. But they may only do so if one of 22 designated NSA officials first determines that the query is based upon a reasonable, articulable suspicion that the phone number at issue is associated with terrorism. Once a reasonable, articulable suspicion-based search is approved, NSA analysts are allowed to do what is known as contact chaining. That is the practice of retrieving not only the phone numbers in direct contact with the number in question, that's known as the first hop, but also all the contact numbers associated with the numbers identified in the first hop, including second hop and even third hop numbers. To give you a sense of how large that field of search might become, if one number contacts, let's say, 100 other numbers, and each of those 100 numbers has 100 contacts, now you have 10,000 at the second hop and 1 million contacts at the third hop. Of course, we're assuming there are no duplicates, which is unlikely, since many of the first hop numbers might know each other and have second hop numbers in common. But still, it's an awful big field to survey. So why did the government care? Why would it want to know everyone who you call and inferentially who you don't call? Well, it's impossible to go anywhere in the world without leaving an electronic footprint, and those footprints tell a story. To see why metadata is important, I want to tell you about an amusing but also fascinating bit of research. It was done by Kieran Healy, who's a sociologist and associate professor at Duke University, where he's a member of the Kenan Institute for Ethics. As a sociologist, Healy frequently uses a form of metadata analysis known as social network analysis. This sort of analysis takes information and uses it to construct a map, not of a physical geography, but of the social geography of a community. In a company, for example, you can find out which employee is the critical linchpin, who routinely shares information between different development groups, say. You can also find out which employee is most responsible for creating team spirit and camaraderie. And of course, the same sort of networking analysis can reveal who is isolated from the group and who doesn't communicate often with anyone. You can decide who to target for influence and who to ignore. Indeed, if you can find the one critical member of a social group and influence that person, then you can, for a relatively small amount of effort, influence the entire network. Professor Healy put the idea to work in an interesting and revelatory way. He imagined himself as living in the 1770s, just prior to the American Revolution. And he further imagined that he was a member of the British government, charged with uncovering a network of American conspirators who were secretly plotting a revolt against their lawful king, King George III of England. Healy speculated how the British might have proceeded if they'd had the sophisticated social network analytical tools available to us today back then. And so he built a social network using data he derived from a book written by David Hackett Fisher about the American Revolution. What Hackett Fisher had done was collect a form of metadata. In this instance, information about the social memberships of men in Boston. He examined which clubs they belonged to and which organizing committees they'd become a part of. Using this data, Healy was able to create a matrix of the connections among Boston revolutionaries. Now, it's important to emphasize that Healy had no idea what the club members might have been saying to each other in their meetings, or even doing. Healy was doing his analysis more than 2 centuries after the co-conspirators might have been breathing life into their rebellion and relying only on metadata. But the same would have been true had British counterterrorism agents conducted a metadata analysis back in 1775. Under this form of surveillance, the British wouldn't necessarily have known anything about what the Bostonians were saying or doing. What Healy did know, and what British counterterrorism specialists might have discovered with a comparable analysis, was that a sufficiently sophisticated analysis could construct a map of the social network in Boston and would have revealed who were the central figures of the Boston male society at the time. The results were fascinating. At the center of the social network graph was a single name. And who do you think would be the one person well known to everybody else in the community, the linchpin, and in whom the British would be most likely to focus their surveillance efforts? Paul Revere. Healy could identify Paul Revere at the center of a suspected rebel plot simply by analyzing who he was socially connected to. Today, through the lens of history, that seems obvious to us, but had the British been able to do this analysis back in the Revolutionary era, it would have been a revelation. And that is the power of metadata. And it explains in a nutshell why the government might be interested in collecting all the records of telephone calls made. So, the next question we might ask is whether the Paul Revere type analysis holds today. In other words, is the telephone metadata program working? The answer is sort of, but modestly at best. The bipartisan Privacy and Civil Liberties Oversight Board in the executive branch of the federal government, which reviews anti-terror programs advanced by the executive branch and also keeps an eye on civil liberties, conducted a full-scale review of the Section 215 metadata program. The board's review suggested that the telephone records collected by the NSA under Section 215 had provided some value, primarily in 2 ways. First, by offering additional leads regarding the context of terrorism suspects already known to investigators, and second, by demonstrating that foreign terrorist plots do not have a U.S. nexus. New leads can help investigators confirm suspicions about the target of an inquiry, or about persons in contact with that target. and identifying the nexus of a foreign plot can help the intelligence community focus its investigative resources by avoiding false leads and channeling efforts where they're most needed. The review suggested that the Section 215 metadata program mostly duplicates the FBI's own lead-generating efforts. Then again, some of the value of the Section 215 program is in its negative information. For example, after the Boston Marathon bombing, some concerns initially surfaced that the ethnic Chechen Tsarnaev brothers might have been acting at the behest of overseas terrorists. Two U.S. intelligence gathering databases, one known as PRISM, which mostly collects information on sender-to-recipient email communications and Internet services, and the other one, the Section 215 metadata program, were used to rule out the possibility that the mayhem unleashed at the Boston Marathon was part of a foreign plot. Based on the young men's phone logs and Internet search activity, investigators became convinced that they were homegrown violent extremists, and that there wasn't anything substantive to tie them to a terrorist group. While that value might be less than if the system had discovered a positive connection, we really shouldn't underestimate the value of establishing that our hypothesis is false. By demonstrating a lack of overseas connection between the Tsarnaevs and foreign actors, the Section 215 and PRISM programs allowed investigators to quickly focus their work on domestic activities, ones that later became the subject matter for the younger brother Tsarnaev's criminal trial for planting the bombs in Boston. The older brother, of course, died in a shootout with the police. The Privacy and Civil Liberties Oversight Board review was generally skeptical of the usefulness of the program. For one thing, as the board said, the best justification for the government's routine collection of all phone records is that it helps in cases where there is no threat to the United States. That is, in cases where there's no real foreign terrorism connection. We should, the board said, find it a bit strange and disturbing that a program officially focused on collection about foreign terrorism, the best use of it is for non-foreign activities. Standing against this limited effectiveness, there are some who say that the 215 program provides grave potential for abuse by the government. And that is fair enough. The potential for abuse is quite realistic and plausible. But the Privacy and Civil Liberties Oversight Board found precious little evidence of actual abuse. Here's what they said in their report on the program. Quote, "Over the years, a series of compliance issues were brought to the attention of the FISA court, that is, the Foreign Intelligence Surveillance Act court, by the government. However, none of these compliance issues involve significant intentional misuse of the system, nor has the board seen any evidence of bad faith or misconduct on the part of any government officials or agents involved with the program. Rather, the compliance issues were recognized by the FISA court and are recognized by the board as a product of the program's technological complexity and vast scope, illustrating the risks inherent in such a program." But even when there is not any abuse, we might reasonably ask whether or not the potential for abuse or the structure of the program has implications for privacy and civil liberties. From that perspective, the concerns are more palpable. The idea that the government holds a database of this magnitude is quite daunting to many citizens, even if the data is used only for the best of purposes. As we've already seen, telephone call records are powerful metadata in and of themselves. Who you call, when, and for how long creates a mosaic that can reveal the most intimate details of your life. If you have a mistress, if you're talking to a cancer doctor or a priest, or even if you're talking to a business competitor about a new job. And we know that telephone call data is not the only type of data that a government, or for that matter, a commercial company might collect. The panoply of publicly available data on a private individual is large and growing larger every day. The concern with the Section 215 program, therefore, is not just with the collection of metadata, but also with the fear that, as the Privacy and Civil Liberties Oversight Board has said, when aggregated with other information and subjected to sophisticated computer analysis, the government's collection of a person's entire telephone calling history will have a significant and detrimental effect on individual privacy. This is all exacerbated when the data is stored for a period of time in the government's databases, where it can be rapidly accessed and searched. In responding to these concerns, Congress has substantially revised the Section 215 program in a bill known as the USA Freedom Act. Under the Act, the law was changed to stop the NSA from continuing its mass phone data collection program. Two principal changes were made. First, instead of the data being collected in a government database, phone companies would now retain the data in their own databases. And they would not be required to hold the data for any longer than their normal business practices require, which is typically around 12 to 18 months. Second, after the law took effect, the NSA would be able to obtain information about targeted individuals only after authorization from the FISA court. And before a particular phone number was selected for analysis and targeting, the government would have to show the court a reasonable, articulable suspicion for why that phone number might be connected to foreign intelligence or terrorism. The most obvious gain in civil liberties from this is that the government would no longer have a large-scale database on all Americans. Many think that the creation of such a database was a fundamental shift in America, one that might have changed it in a core, almost inexpressible way. Because the government has a monopoly on the lawful use of force in society, it also represents a unique threat to the liberty and privacy of citizens in ways fundamentally different than potential threats to privacy and civil liberties posed by corporate data collectors. We worry that the government's collection of data for one purpose might be in the future repurposed to a less well-justified end. Abuse tends to be insidious, proceeding incrementally. And even if you think the chances of it are remote, the history of intelligence-related ethical lapses by the US government and by more authoritarian countries should give us all pause. If, like me, you think that the corrective mechanisms of US government are strong, we must acknowledge that a risk of abuse is nonetheless more than merely theoretical. And that leads to a second-order effect. We worry that even the fear of potential abuse can have an indirect effect on freedom and liberty. Some argue that the creation of a telephone records database could have a chilling effect on the free exercise of speech and association. According to this argument, those who engage in controversial activities might not trust the government to honor their rights to privacy. Note, importantly, that this concern is not about the privacy of unlawful activity. It's about the privacy of lawful, but perhaps disfavored activity. Concerned about their liberty and privacy interests, social activists and even non-activist dissidents might either forego perfectly lawful private activities or modify their conduct in very costly ways. For example, having in-person meetings instead of communicating by phone. One obvious example where the fear of government intrusion on private conduct might apply is the communications between, for example, journalists and their confidential sources. So consider as just one small example of this problem, the litigation known as NAACP versus Alabama. The case comes to us from the civil rights era of the late 1950s. The NAACP, or National Association for the Advancement of Colored People, took a position strongly in favor of desegregation and the end of discriminatory Jim Crow laws. Alabama, under the guise of corporate governance, demanded that the NAACP turn over its membership list. The NAACP was understandably skeptical of Alabama's intentions and sought protection from the courts. The U.S. Supreme Court unanimously ruled that membership lists were an aspect of the protected freedom of association and speech, and that the government could not demand that the records be produced. With that as a background, consider this question. How do we feel about the US government using call record metadata to identify, say, the membership of the local Tea Party or the local MoveOn.org group? For obvious reasons, many see this as also problematic. A final note. We should not see the distributed system, where the phone companies keep the call data, as a complete panacea. For one thing, requiring the phone companies to hold the data increases the ability of commercial providers to analyze the data. And some people have even less confidence in commercial data aggregators than they do in the government. For another, the requirement will inevitably make government less efficient at scrutinizing potential terrorist activity. That's a cost that comes with a distributed database that we will have to accept as the price of increased privacy. For now, Congress has made that judgment in response to the concerns of the American public. Only time will tell if the choice was a wise one. So let's now ask again, is the Section 215 program legal? To simplify the question, let's just focus on the statutory text. The text of Section 215, until it was changed by Congress, said that the government may secure an order, quote, requiring the production of any tangible things, including books, records, papers, documents, and other items, for an investigation to obtain foreign intelligence information. So far, that's pretty standard stuff. But the key to Section 215 and the debate is the further requirement that there are, quote, reasonable grounds to believe that the tangible things sought are relevant to an authorized investigation to protect against international terrorism. Some read this language as one of great specificity, that an authorized investigation is singular in nature and targeted at a relatively particular individual or group of individuals. Now, from this perspective, we have to put a fair amount of weight on the word "an," the authorized investigation. This argues that the concept of relevance is relatively narrow and a directed idea. One law dictionary I use, for example, defines relevance as that which conduces to the proof of a pertinent hypothesis. That's a mouthful. You must, in this view, have an articulable hypothesis you're trying to prove or disprove, which suggests a narrow focus to the inquiry. Or, as William Snapwire said once, it means you have to explain in words on the judicial record exactly why you're seeking the records. By contrast, the government has argued and convinced the FISA court of its views that there is a reasonable basis for believing that the broad bulk collection of metadata is likely to be relevant to an authorized investigation. That is, an investigation of foreign terrorist activity, more broadly and generally conceived. The Justice Department has argued that there's no a priori reason that an investigation to protect against international terrorism should be narrow, given the far-flung and convoluted nature of terrorist organizations. In the debates on Section 215, former Arizona Senator John Kyle and others noted the resourceful nature of terrorist groups and the agility demanded of U.S. responses. Or as one district court judge put it, opponents argue that the category at issue, all telephony metadata, is too broad and contains too much irrelevant information. That argument, he said, has no traction here, because without all the data points, the government cannot be certain it has connected the pertinent ones. As you might imagine, in such a debatable legal issue, opinions differ on the meaning of the text. When the Second Circuit Court of Appeals in New York was asked the question, it ruled the other way, against the government. It said this: the government's approach essentially reads the authorized investigation language out of the statute. Indeed, the government's information gathering under the telephone metadata program is inconsistent with the very concept of an investigation. To investigate something, according to the Oxford English Dictionary, is to search or inquire into, to examine a matter systematically or in detail, to make an inquiry or examination into. Section 215's language, the court said, thus contemplates the specificity of a particular investigation, not the general counterterrorism intelligence efforts of the United States government. So I want to end this discussion of the statutory text by talking about fish. Maybe that sounds like a strange place to conclude, but trust me, it's relevant. And here I want to thank Tim Edgar, a former senior legal advisor in the Office of the Director of National Intelligence, who was the first to develop the analysis and idea that I'm about to share with you. The fish were a critical part of a Supreme Court case, Yates versus United States. Yates was accused of catching undersized fish in violation of federal fishing law, a misdemeanor. He was also accused of throwing the undersized fish overboard when he was caught by a U.S. Fish and Wildlife inspector. Oddly enough, he was charged under a section of the Federal Criminal Code, Section 1519, that makes a defendant subject to up to 20 years in prison if he or she, and now I'm quoting, knowingly alters, destroys, mutilates, conceals, covers up, falsifies, or makes a false entry in any record, document, or tangible object. The government said that by destroying the fish, Yates was destroying a tangible object, and that he could go to jail for 20 years. Yates objected. He said that the law the prosecutors had used against him was part of congressional legislation related to financial reforms, and that words like records and documents should be read to limit tangible objects to things that were related to financial fraud. And Yates won. The Supreme Court opinion, written by Justice Ruth Bader Ginsburg, said that in law as in life, the same words placed in different contexts sometimes mean different things. And as for the statute in question, Ginsburg wrote that tangible object would have to mean objects used to record or preserve information, not every object in the world like a fish or a hat. So perhaps you can see now the parallel. Section 215 of the Patriot Act authorizes the government to have access to business records for foreign intelligence purposes. It allows the government to obtain an order from the court for the production of any tangible thing, including books, records, papers, documents, and other items. Does this language literally mean the government can get any tangible thing? If it does, then the statutory foundation of the bulk metadata collection program is pretty solid. But if we take Yates seriously, then we tend to think that large, capacious catch-all phrases like any tangible thing or tangible object are limited by the context in which they appear. Clearly, telephone records of individual calls would seem to be fairly within the scope of Section 215. They are a tangible record of an event. But it is at least an open question whether the entire database of every major phone company in the United States is a tangible thing. It might well be that bulk collection of the telephony metadata database is as different from an ordinary business record as a fish is from a bank document. And what of the constitutionality of the Section 215 program? Doesn't the Fourth Amendment protect against this sort of governmental intrusion? Isn't the Section 215 program an unreasonable search and seizure? The answers we have aren't terribly clear. For now, let's just record that so far the courts are split on the question, as is the Privacy and Civil Liberties Oversight Board. And as big as the question is, I suspect the constitutionality of the Section 215 program will never be decided. And that's because, in reaction to privacy concerns, Congress listened, and it significantly changed the program.